All right, we are here and live with Judge Doug Harpool. Sir, thank you for joining us.
My pleasure.
Could you take a little bit to tell, we are learning about the judicial chapter right now. What are you? What do you do? What's your job like on a day-to-day basis?
I am a federal district judge. That is a judgeship created under Article 3 of the United States Constitution. It is a lifetime appointment. It was made by the president with confirmation by the Senate. I've been in this position since 2014. I have jurisdiction over federal cases that arise in the western half of Missouri. That includes Jeff City and Columbia and West Plains on our side of the state. It goes all the way from Iowa to Arkansas and all across the western border. There are 6 judges who have the same position I do. 5 of them have chambers in Kansas City. My chambers are in Springfield, but we all have cases all over the district. And we have courthouses in Kansas City, Springfield, and Jeff City. As a federal district judge, I handle federal cases involving federal crimes. I handle cases involving federal civil jurisdiction, and there's really basically 2 types of those. There's cases that arise under federal law, such as employment statutes and things like that, antitrust. And then I handle cases where there's a dispute between people of different states. We call that diversity jurisdiction, and I handle those civil cases. There's then, in addition to the criminal and civil cases, there's some other types of responsibilities I have. One of them is I approve wiretaps that are requested by the U.S. Attorney's Office. I have to go through and make sure they're in appropriate form and approve them. I also supervise the grand jury. I pick a grand jury and supervise it, and when it decides who should be indicted for a federal crime. And then I handle naturalization ceremonies where people are wanting to be U.S. citizens, and I conduct the ceremony and administer the oath allowing them to become citizens when the immigration service determines that they've met, naturalization immigration service determines they've met all the qualities. So those are my duties and responsibilities. It is a lifetime appointment. I can hold this job as long as I'm alive and able to. We have a judge in our district who is what we call a senior judge. That's a judge who once was like me, that's active, but who has gone into semi-retirement. He's 92, and he still handles a few cases for us. So it is something you expect when you take the job, you expect to keep it until you're simply not able to do the job anymore. And that's what I plan on doing.
So just to be clear, you work in that district. Can you name your district one more time?
It's the Western District of Missouri.
But
so it takes the western half of Missouri.
You are not the judge for that district. You are one of a rotating cast, correct?
There are 6 judges who handle it, yes. My cases mainly arise out of what we call the Springfield docket. That's the Southern and Southwest Division. But I do have some cases in Jeff City and a few that are actually in Kansas City and St. Joe divisions. Very few up there.
Gotcha. Now, let's start at the very beginning, because you are a judge because you were appointed to that position. When a vacancy opened up, is it typical for people like yourself to advertise for the position, to put in an application to the president, hey, I'd be really good for this position, or do they approach you?
I don't think there's any rule of thumb as to how it happens. But typically, if it's a federal district judge under Article 3, which is a presidential appointment, then the U.S. Senator of the state makes the nomination to the president. The senior U.S. Senator makes a nomination to the president as to who they think would be a good choice. I know when President Obama was president, he required 3 names to be submitted by the U.S. Senator, and then they would review the 3 and they would select one to take the position. There is a lot of politicking that goes on, but in the end, it's a presidential decision based on recommendation of the U.S. Senate. At one time, the U.S. Senate had a policy called the blue slip policy. And if the senator from that state didn't fill out a blue slip and turn it into the Judiciary Chairman of the Senate, then the Judiciary Committee would not take up that nomination. So the U.S. Senator plays a tremendously powerful role in determining who the district judges will be.
That is, if you read Article 3 only says the president appoints and the Senate confirms. I'd like to talk to you about that here in a minute. But you are saying there is a large informal role for the senators of that state, correct?
There are, in some states, senators haven't wanted that role because for everybody you pick, you've not picked other people and it had caused them some political problems. So some of them have created informal screening panels that the senator picks who's on the panel, but then this panel goes through and decides whose names would be sent to the president. That is not how it worked in my situation, though.
So you were appointed, you were tapped, this is the word they often say, by President Obama. What was that did you get to talk to him? What was the process like being appointed and then having the Senate poke and prod you to figure out if you were right for the position?
It was arduous. Let me start with the idea that Senator McCaskill, who was then the senior senator from Missouri, and I served together in the legislature. And I had worked on her campaigns. And in fact, when she did practice debates for her campaigns, I was always her opponent. I was the one who played the opponent. So I knew Claire well. And when a vacancy came open down here, she and I informally had a conversation and she said, would you be interested? Prior to that date, I had thought in the back of my mind about the possibility, but hadn't really been excited about it. But when she suggested it and I thought about it, I thought that was a career move that I wanted to make. I loved public service when I was in the legislature, and it's an opportunity to get back into public service and yet follow up on the career that I've had in the practice of law. So when she said that I would be one of the names that she would submit, then I got contacted by the Department of Justice, and the Department of Justice did a thorough investigation and had me fill out hundreds of pages. And I had to submit every newspaper article that had ever quoted me, every speech I had ever given to a club, any video where I'd appeared on television that I had it. And I submitted all of that to the Department of Justice. They then had the FBI do an investigation of me, looking into not just formal records, but they knocked on neighbors' doors. They inquired of the judges that I had been in front of. They talked to my law partners. They talked to people I served with in the legislature, and they wrote a report. And then the ABA, the American Bar Association, was contacted, and they did an evaluation of my performance as a lawyer to determine whether or not I would be appropriately tempered to be a judge. After all those three things happened, then the Department of Justice filed a report to the president, and I talked to the president's appointments staff. And after that interview, I received a phone call from Senator McCaskill, who advised me that I was going to be nominated by President Obama. After that, then, the U.S. Senate Committee, Judiciary Committee staff began their investigation. There was another complete set of questions. They had some follow-up questions from some of the answers I'd given the Department of Justice. They asked for some additional materials about me. So I submitted all those to them, and then we had our hearing. And I appeared in front of the Judiciary Committee and had a hearing where the staff and the senators had the opportunity to ask me questions about legal issues and positions and my preparation and as a lawyer. However, when that happened, the U.S. Senate term ended and the Senate committee adjourned without ever voting on me. And so then the next term, my name was resubmitted by the president, and the judiciary chairman then decided that we didn't need to have another hearing and didn't put my name up for vote, and I was approved. It took about, well, it was August when the president formally nominated me, and it was February when I was formally voted on. But I had been working with the judiciary staff for 5 months before the president ever nominated me. So it was almost a full year of scrutiny and inquiries before I knew whether I'd be appointed or not.
You know, I looked up that February vote, and 90 some senators voted to confirm you, which I understand is relatively, for like non-controversial judges, relatively common. They defer pretty heavily to the committee in that regard. But I was looking at the senators that voted against you, and there's only a handful of them, and normally I don't care enough about that. But one of them was John McCain, which our older voters, or older students in the class may remember, ran for president many, many years ago and was widely regarded as a very highly influential. I mean, did you get any indication that he was going to vote against you, or any of the people that voted against you were going to vote against you?
I had no communication with anybody who was going to vote against me. Both Missouri senators voted for me, by the way, Senator Blunt and Senator McCaskill. Of course, I've known Senator Blunt for many, many years because we both grew up here in Springfield, or he grew up just outside of Springfield. And actually, I was surprised by Senator McCain because when I was in the legislature, one of the things I did was aggressively fight for governmental ethics and campaign finance. And as you know, one of the things John McCain's known for is the McCain-Feingold bill, which was to instill campaign finance regulations at the federal level. I asked Senator McCaskill later, I said, do you have any idea why he voted against me? And she said, oh, he was mad at me over something. So who knows?
I got to imagine that of all the positions in government that require thick skin, your position, as well as all the other judges and justices that serve with you, I mean, you guys got to have the thickest skin in America. Would you think that's appropriate to say?
It is. In fact, I often give speeches, to lawyers and things. I say I have a job where it's almost guaranteed I'll make one of two people mad every time I make a decision. The idea of pleasing people, it's almost impossible because you have people who want different results. And so you have to have thick skin because it doesn't matter what decision you make, somebody's going to be angry at it. That's one reason why I like our, sometimes, by the way, I manage to make both sides mad with a decision. I love naturalization ceremonies because that's the one thing I do where everybody leaves happy. And that's really, it's the only thing I do that everybody leaves happy.
The court system is famous for the Supreme Court and having to decide these gigantic constitutional questions. I know that you, in your role, we have, in class, we've talked about kind of the pyramid. You have the district courts, then the appeals courts, and the Supreme Court. You deal with a lot of civil cases. You deal with some criminal cases. Do you ever find yourself dealing, I don't know exactly how much you deal with those big constitutional questions?
Occasionally. It's certainly not the majority of cases I have. And there are probably three I can think of that were fairly significant in the last 7 years. I had one involving the separation of church and state, involving the school system and involvement with the local church. I had one involving whether or not you could require the wearing of masks under the COVID against the city of Springfield. And then I had one had to do with employment opportunities. That arguably was more statutory than constitutional, but it has some constitutional implications. And other than that, the overwhelming majority, well, I take it back, I had one other, was a commercial speech argument involving regulations in the state of Missouri over advertising alcohol. And that was a First Amendment question, but that's four. And I have, at any given time, I have 200 civil cases pending in 7 years. So out of 1,400 cases, I can only think of four that I actually handled a true constitutional question that wasn't clearly answered by precedent.
Well, regardless of these constitutional questions, your decisions get appealed, as all judges do, and they get appealed up to the courts of appeal. I know that getting appealed is part of the job description, but I haven't looked up your statistics or anything. But when an upper court either remands or reverses something you've said, what is that like? I don't know. I can't imagine what that might be like.
Well, it kind of depends. There was, honestly, there was one case where I got reversed and I read what the appellate court read and I said, they're right, I missed something. There have been another couple of times I've been reversed where at the time I made the decision, I said, there is no clear answer to this. My best guess is this what's going to happen. And the appellate court on a split decision would tell me what the answer is. So they didn't agree either. So yeah, I don't take too much offense at that. I mean, not every question of law is clear cut. It's not all certain. And there have been a couple of times I've been reversed and I'm convinced the Court of Appeals is wrong. And I think if it ever gets to the Supreme Court, they'll rule the way I suggested, but those cases didn't get appealed on. But you have to have, like you said earlier, you have to have thick skin. They are tough calls sometimes.
Do you have any say in the cases you get, or do they get plopped on your desk?
It's a random assignment basis, and no, I don't have any say. Now, with the exception if I have a conflict of interest. Obviously, I get to submit a list of conflicts of interest, and if I get a case where I have a conflict I didn't realize I would have, then I have to recuse myself. But other than that, I have no say. Whatever they assign to me, I take.
Now, one of the things that I think we overlook, we take for granted here in America, there is risk associated with your position. One of your colleagues, I forget which one of your colleagues, but I know it was a woman, one of your colleagues had her family killed. Yeah. How do you manage those risks? How do you manage those dangers? How does the U.S. government and the law manage those dangers?
We had a terrible tragedy, and several years ago there was another one in Chicago, kind of similar to what happened now. And there isn't any absolute guarantee. The U.S. Marshal Service does provide security, but obviously they can't be right next to me 24 hours a day the way Secret Service is with the president. So, but if I'm ever in need, I have a special number, the Marshal Service, I call them. And at the courthouse, the Marshal Service supervises security. I try to stay off of Facebook. I try to stay off of all social media so people don't know where I'm going to be, when I'm going to be there. I encourage my family that if they're going to be on Facebook, just don't ever mention whether I'm going to be present at an outing or not. I don't put on when I'm going on vacation or where I'm going on vacation or what I do. Those things we don't advertise. I am provided a security system at my home, which would immediately ring the marshals and the police if there was a break-in. Other than that, I try really, really hard to treat everybody that comes in front of me like a human being, like a person, and to treat them with respect. Some of them have done horrible things, but I still try to treat them as a person and not do anything that would antagonize them any more than what my decision is likely to do. And certainly my decisions are sufficient to antagonize some people. When you put someone in jail for a long time, it angers them. Interestingly, most of the threats that federal judges receive, I'm told, come from civil litigants who are disappointed with the outcome of civil lawsuits. And the criminal defendants are kind of more monitored by the system. Many of them, when we put them in jail, they're there for a long time. But the civil litigants we may rule against, and we tend to see the criminal defendants, but we don't always see the civil litigants. And so we don't even know what they look like sometimes. So
while you were speaking, I looked up her name. It was Esther Salas. Esther Salas.
Right. From New Jersey?
Was that?
Is it New Jersey she was from?
Home in New Jersey. And again,
right.
She was not attacked. Unfortunately, her family was attacked.
Right. And it was by a lawyer, interestingly enough, which is very unusual.
And I did want to ask a little bit more about that. Esther Salas, in her speech, because she gave a very emotional recorded speech. I don't know if you knew her. It has to be heart-wrenching to see a colleague go through that.
It is. I had never met her, but it's heart-wrenching.
she had advocated for changes to law to make it safer for her. I don't know if you'd had thought about those issues yourself, if you have any thoughts on that.
Well, the Federal Judges Association, which I'm a member, has proposed some changes to the Congress. And it basically makes it harder to put personal identifying information of federal judges on the internet, home addresses, things like that, so that people who are acting irrationally have a harder time locating the judge and the judge's address. And I certainly am supportive of those changes. It was disappointing it didn't pass the last session. Some senator had a problem with it. And so I think it's now been reintroduced and it's going to go through the whole process again.
I wouldn't talk too much about that, but it's a part of your life that I take for granted. Nobody cares about me, but you are very, very, very important. Now, with that in mind, as we have talked about in class, the Constitution leaves it up to Congress to determine the structure of the court system, how many courts we have. And there has been some bipartisan grumbling by Democrats and Republicans to maybe expand the number of courts that we have. What are your thoughts on that, if you have any?
Well, let me use this as an opportunity to say that one of the things I've been able to do recently is I've been chosen to sit as a special judge on the Ninth Circuit Court of Appeals. And in fact, tomorrow I'm appearing via Zoom on the Ninth Circuit Court of Appeals, so one court up from the one I'm normally on. And that kind of gives you a different perspective. And
what is a special judge?
It's simply a judge that normally does not sit with that court, but the Supreme Court has signed an order saying that that court is in need of additional assistance. And then my court has to sign off and approve me taking some of my time and going to help that judge. That court is one that typically is using special judges because their volume has outpaced the number of judges that have been authorized. I know that there are district courts that are in need of additional judges. I don't feel that we necessarily are. We could probably use another magistrate judge, which is one judge below me that we appoint that handles more routine criminal matters, the introductory criminal matters. But I do think we need some additional judges to be approved. The problem with approving new judges is strictly political. When the Democrats are in the presidency, they want to create new judges, but when the Republicans are, the Democrats don't, and vice versa. It's hard to find the right time to do it. We're hopeful that maybe some new ones will get approved this term. There's also some discussion of changing the number of states that are in some of the circuits. For example, the Ninth Circuit, and either creating a new circuit or taking some of the states now in the Ninth Circuit and moving it to a different circuit. Anything that will eliminate the backlog in the courts is positive, because delay in the courts delays justice.
I did want to ask about some famous issues that you've had to deal with before. Most recently, as you mentioned, you dealt with the COVID mask questions regarding Springfield, Missouri. Now, our students, I'll be recording this, and in the future, students may not remember. Could you kind of walk us through what that was about? What happened? What was your decision? Kind of the fallout from it?
The city of Springfield passed an ordinance saying that you had to wear a mask in public places. There was a citizen who objected to that on the grounds that she claimed that wearing a mask was caused her to be claustrophobic, and also opened her to criticism by fellow citizens if she didn't wear a mask, and possible prosecution. I ruled that the mask ordinance enacted by the city was legal, and I did so partly because I'm going to say that it was a flawed plaintiff, in that the ordinance passed by the city gave an exemption to people who were claustrophobic. And so if you declared you were claustrophobic, you didn't have to wear a mask. Her argument then became, well, but people will get on me if I don't have a mask. And to me, that wasn't a fault of the ordinance. That would be a fault of other people if they weren't understanding. She argued that she wouldn't be able to go to church because her church required masks. And my argument was that's your church's decision, because you're exempt from the city ordinance. It's your church's decision that you shouldn't be there without a mask. And that church certainly had a right to set that rule if they wanted to. So I declared that the city ordinance was constitutional.
Gotcha. And like just on when it comes to your position, I mentioned a moment ago security. I don't know if how often we think about judges' security, but there's got to be other areas, other aspects of your job that we, the people, simply don't think about or are aware of. If you could shine a light in a crevice of your job that we should be more aware of, what do you think that would be?
I'll talk specifically. My job in Springfield is the presence of the Springfield Medical Center. We have a large mental health unit in the Springfield Medical Center, and prisons from all across the country transfer their patients here for mental evaluations. And if an inmate at that facility is in need of medication and refuses to take it, or if that inmate is in need of being transferred to the mental health section of the prison rather than the general population of the prison, I have to approve that. Then if their prison term is over, but the prison staff and psychologists believe the person still is a danger to themselves or to others due to their mental illness, then I have what is basically a civil proceeding to determine whether or not they should be detained in the mental health facility beyond their actual criminal sentence. And we have 8 to 10 cases like that every month that Judge Rush, the magistrate, helps me with, that we rule on. And I think the average person has no idea how big that is. We have a huge, the prison here in Springfield also has a very large facility for dialysis. So it's an integral part of the federal criminal justice system, and it creates a lot of work for our local court that others don't have. The other thing is the wiretaps. I think a lot of people don't think about wiretaps, but I consider 8 to 12 wiretap applications a year, and each one of them is about 1.5 inches thick, and we authorize certain people's phones to be tapped, and then we have to receive reports every 2 weeks about what the phone calls have found, and then we're required to shut them down if we think that they are no longer producing any evidence of criminal activity.
One of the last things, and I'll just leave us with your parting shot on this. Once again, Doug Harpool, thank you so much for joining us. One of the things we talk about whenever we review this chapter is the dueling philosophies of how active the judicial branch should be when it comes to the other two branches. We have a theory that goes judicial restraint, and that judges and the judicial branch as a whole should defer to the other two elected branches every step of the way, except when it's egregious. And then there's judicial activism, which carries all sorts of meanings these days, but generally meaning that regardless of how you got to your position, you're a co-equal branch of government. And if that means being proactive and slapping down the other branches from time to time, so be it. On that divide, how do you feel about it? Do you come down on a side? What are your thoughts?
Well, let me start with the idea that the two political parties are not capable of being consistent in their definition of activism or restraint. It depends on what the outcome they want. And when they want a certain outcome, they want the courts to help them, then they want an active court. And when they want a different outcome and they don't want to, then they want the courts to say that to be restrained. And they're not consistent. And it's just political smoke whenever you hear them arguing about activism or restraint. I think those are terms that are applicable, but you can't listen to the politicians use them because they use them based on outcome rather than based on substance. As for me, I think by far the most important role of the courts is to protect constitutional rights. The Constitution only has meaning if there's someone out there giving it meaning. And anytime either of the other two branches of government infringe upon the Constitution, it's up to the courts to stop it. And the courts have failed a few times in history to take steps they should have. But there are other times we stood up and did what needed to be done. There's no question there are times where presidential action violates the Constitution. There are times in which congressional action violates the Constitution. And it's our job to interpret the Constitution and to keep both of those branches in check. But we've got to do so not based on outcome, not based on what political agenda we want or what political outcome we want. We've got to do it based on what we think the true meaning of the Constitution is. And there's room for debate in what the Constitution means. And there's debates on whether the Constitution grows and changes with time or whether it's a stagnant document that should be interpreted solely based on what it was meant at the time it was enacted. And those arguments are ones that can be made within the court by very intelligent people and are made by intelligent people. But that intelligence gets lost when the people making the interpretation have political agendas. And I fear that's happened too often. There is no solution other than selecting the right people to serve on the courts. And that means selecting people who you think will make the honest decision that need to be made and not just the decision you want them to make. And I fear that the judicial selection process in recent years has fallen aside. I told you earlier that the ABA does an evaluation, and I was found to be highly qualified based on my career as a lawyer. Now we're seeing judges approved that really come from political environments sometimes, who don't have long practices in law or in studying law, and who don't have that rating from the ABA. And it concerns me because I fear those people come not with a love for the law or a integrity for the law, but with a political agenda. And that's what we have to watch to keep our branch. If we fall into that category, then we'll fail our responsibility.
Judge Harpool, thank you so much for joining us. And I know we're doing this by Zoom because everything is terrible right now, but hopefully in a future semester you can swing by in person. Okay, sir?
It's my pleasure. You can tell I'm working from home today, getting ready for my 9th circuit. So I'll look better if I ever show up in your class. Okay.
Okay, I'll hold you to that.
Thank you.
Take care.